Hi, I'm Tom Moukawsher, Connecticut complex litigation judge. Let's talk today about why some of us are disappointed in the courts and what we can do about it. Courts are meant to be problem solvers, yet today, 99% of cases never get a trial. Many are thrown out on technicalities. Courts judge others to be simply too weak, and many end with coaxed or even coerced settlements. Whatever happens, it usually takes years. And unfortunately, when judges do write decisions, too often we can't understand what they're saying. It's like they're talking to us with a mouthful of food or something. Now, I think the reason for this is that courts are increasingly obsessed with the forms and the formulas of a lawsuit over the substance of a lawsuit, the thing that made one party sue another. Now, you may think that this is just the way courts have always been, and you'd be partially right, but not entirely. In the 20th century, we had prominent pragmatists on the bench, like Oliver Wendell Holmes, Justice Louis Brandeis, Judge Learned Hand, and others. They usually went straight for the jugular of a case. And when they decided it, we knew who won and we knew why. Now, all you have to do to see this in action is to read something you already know about without ever having read the actual decision. Justice Oliver Wendell Holmes' decision in Schenck versus United States. That's where he wrote that free speech doesn't entitle us to shout fire in a crowded theater. Government may restrict speech when it presents a clear and present danger. And that's every bit as good today as it was when he wrote it in 1919. No wonder Tom Clancy used it as a movie title. But today's courts are dominated by formalists who take the main issue at hand and often look at it historically or focus on other things that smother the real judgments being made. Let's take two examples. One you might perceive as a conservative outcome and one you might perceive as a liberal outcome. But the politics don't matter here. First, let's look at the 2022 abortion decision. Justice Samuel Alito wrote the majority decision in Dobbs versus Jackson Women's Health Organization. Now, regardless of what you think of the result, Justice Alito's approach was a typical example of formalism. In Dobbs, Justice Alito followed his favorite formula, originalism. What matters, he said, was whether women had the right to an abortion in history and tradition. Most of his opinion was spent proving that prior to Roe versus Wade, there had been no history or tradition of women having the legal right to an abortion. But this only means that most of Justice Alito's opinion was about trying to prove to something to us we already know. Women had no historic legal right to an abortion because in history, women basically had no legal rights at all. Justice Alito never explained why he had to go that way. Justice Alito never said why he framed what he was looking at so narrowly. We don't know why he said the main question was the history of abortion, rather than let's say the history of physical freedom from government restraint, or as Roe versus Wade said, the history of privacy, a well-recognized American right. Why look for the word abortion in the 14th Amendment when we know it isn't there, when you can so easily find the word liberty and decide how far it goes? I mean, the Supreme Court didn't look for the word schools in the 14th Amendment, or the word segregation for that matter, before deciding school segregation was illegal in Brown versus Board of Education. Should we have looked in for the word AR-15 in the Second Amendment and found them permissibly regulated because they're not mentioned in the Constitution? Now, Justice Alito didn't explain why it was fair to look chiefly to the history and tradition when considering the rights of the historically oppressed. Yes, the court has applied the history and tradition test, along with other tests, to measure liberty rights in the past, but it never before used history and tradition to measure the rights of the historically oppressed. Now, Justice Alito's Dobbs decision thus turns on an unjustified decision to search in the wrong place for the wrong right. That's what happens when the form of the inquiry triumphs over its substance. It's high formalism. It left us with a case of great historic importance on an issue of great national controversy, with a long and empty history lesson to justify the main reason for the case and coming out the way that it did. Now, if you think this is all about me being in favor of abortion rights, you'd be wrong. I'm not taking any position on abortion rights. I'm simply in favor of judges recognizing the pivotal choices they make and then justify. To prove it, let's take a look at a decision by the court most often accused of being left-leaning, the Ninth Circuit Court of Appeals. At least Justice Alito was trying to prove a point, even if it was an irrelevant one. Most contemporary formalism is far worse. Let's consider now the Ninth Circuit's 2022 decision about the homeless in Johnson versus City of Grants Pass. pages. It spent 34 pages before even reaching the main question to be decided, and then spent almost no time considering, in the court's own words, the human implications of its decisions for the homeless, the police, and the city officials who have to live with the broad implications of its ruling concerning anti-camping ordinances. Like most court decisions today, it gave most of its attention to jurisdictional questions, the case history, a disembodied list of facts, and the background law, but then only spent a fraction of that time justifying the court's key ruling that governments may not criminalize sleeping in public, including by criminalizing sleeping bags and bedding for those with no place to go. Perhaps it's just become easier to point to mechanical means of reaching a decision rather than dealing with the flesh, the bones, and the blood of a living controversy. But this should worry us. The triumph of formalism in American courts has coincided with a deep decline in public respect for them. There's just no reason we have to keep harming ourselves this way. Lawyers in courts only have to start talking about the basic claim at stake instead of avoiding the subject and using unexplained assumptions and endless throat clearing as substitutes. Trial courts should say who wins and why under the basic legal principle at stake and under the facts in front of them, not something else from some other case that isn't even binding. Appellate courts should develop understandable legal standards and justify them in human terms. How are they going to affect the lives of the parties in front of them and those who come after them? Appellate courts should have the courage to speak in their own voices and not speak principally through disembodied quotations from decisions that don't bind them and that they've chosen to quote over some other contrary decisions. It's not so very much to ask. Decisions are actually easier to write when judges see them for what they are, their opinions, governed by statute and binding precedent, of course, but still under the facts of each case, matters of judgment by a human about other humans. Whatever a judge's perspective, all judges have a stake in writing credible opinions for the sake of a credible judiciary and indeed a more stable America. Cases have basic human questions at the core of them. They should be considered directly by lawyers and decided by judges succinctly. It's avoiding the main question that's failing us. It's the detours that make legal proceedings longer and less credible. Now, to wrap up, let's be briefly and brutally specific. In their writing, judges and indeed lawyers too should drop independent sections about procedural postures, the standard of review, lower court rulings, the contentions of the parties, the background law, etc. Because those things should only be discussed where they're needed and if they're needed. In other words, a brief or a legal decision should directly justify the main decision first, weaving the other matters mentioned in as needed and as secondary consideration. Formalism is about making these lesser matters matter most. Above all, we should remember that the more the legal profession focuses on real disputes, the more real respect it will gain. Thanks for watching. To learn more, look for my videos or read my book, The Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce it, from Brandeis University Press. Thank you.